Right.
May it please the court.
Third.
My name is Sherman B. I represent BBK Santoshi, the appellant in the case. I'm first thing I'd like to say is that I want to use short names in the interest of brevity, and I'm just going to call BBK Santoshi LLC. I'm just going to call it BBK. And Chicago Title Insurance Company, I'm just going to call Chicago, if that's all right.
You want some rebuttal time, sir?
I'm sorry?
Do you want some rebuttal time?
Yes, sir. 5 minutes, please.
Very well.
And if you give me a 2-minute warning, I would appreciate it. The background of this was very simple. The principals of BBK Santoshi were looking to buy a hotel. They found this property, they inspected it, and they evaluated it before making an offer to purchase. And when they evaluated it, they were evaluating a hotel with a sign and an outbuilding in front that was on the primary road that had a building that had previously in the past been used for a restaurant. That's how big it was. And it had two freestanding signs, which were no longer allowed to be built in the city, but the existing freestanding signs were grandfathered in. So they evaluated that they would be one sign to use for the hotel, one sign to use for the freestanding building. With that in mind, they could see clearly that the hotel was using the outbuilding as the office and storage and for conventions, whatever, for the hotel. They weren't using it for any other purpose, so they were only using one sign. The gas station abutting the property was using the second sign for the gas station. They didn't mind the gas station using the sign until they needed it for the outbuilding, but they didn't want to run into a lease, so they asked, is there a lease? They asked the seller, is there a lease? They were told, no, there is no lease. At the closing, there was the usual document signed by the seller saying there are no leases. So they had no reason to believe that there was a lease. And they went ahead and they evaluated the property they thought they were buying, two signs, an outbuilding, and a hotel. It was some years later before they wanted they tried to rent the sign and found out that they can't because of the lease. That's the first time that they found out that there was a lease. They immediately went upon finding out there was a lease. They contacted Chicago Title, who had insured the title, and said there were no defects on the title. And hence we filed the suit. As their defense, Chicago Title says, well, the sign has to be an offsite sign. Therefore, the purpose of the lease was to erect the sign. Therefore, it's an illegal lease that can't be enforced. So even though there's an encumbrance, the encumbrance is unenforceable, and hence we don't owe anything. And based on that, the trial court granted their motion. Now, why did they say it was an illegal offsite sign? Because they didn't understand that there was a 99-year lease, which was part of the complaint. It was an attachment to the complaint. And the 99-year lease made the property that the 87 square feet of land that was leased contiguous to the gas station, part of the gas station's property, or part of the gas stations, I believe they called it a zoning lot. In one code and another code, they called it a parcel. In any event, how do we know this? We know this because the person who owned the gas station at the time and paid somebody to erect the sign, went to the city and asked for a permit. He got a permit. They couldn't put the sign where he wanted it. And because of the way the layout, the way the gas station was laid out, the canopy was already there. The underground piping was there, the tanks. He had no other place to put it. So he asked the head of the department in the city department that issues the permits, can I put it on my neighbor's property? He was told no, but let me look into it. The head of the department talked with the head of the zoning department. He talked with the assistant city attorney who handled that area, and both of them agreed that if he got a 99-year lease to the property, it would make that property part of the zoning lot or part of the parcel, and they could go ahead and put the sign up. It would be legal, it would not be off-site because it's part of the parcel. So with that in mind, he put up the sign. Now, the Chicago Title knew about the testimony of the person from the gas station, and that was direct evidence that the sign was legal. But they got a copy of the file from the city that was several years old, and that had since been gone from paper to having been scanned and electronically. And in any event, what they found was there was no evidence that a permit had been issued. And now that is circumstantial evidence, because it's the fact that there was no evidence in that file that it had been issued is no more circumstantial evidence than it's a circumstance that it was lost.
City of Tampa ended up ordering them.
I'm sorry, Your Honor.
City of Tampa ordered them to remove the sign.
I do apologize. I'm hard of hearing.
The city of Tampa ordered the sign to be removed.
Yes, sir. That's what I'm getting to. The Chicago Title had their appraiser call the zoning department and complain about a sign that was off-site. And they didn't bother to tell them about a 99-year lease. That person that they called the code enforcement department and said, "Hey, we've got an off-site sign here." They even sent a copy of the survey that we had given them in discovery that clearly showed that the sign was our sign on our property. It didn't show the 99-year lease, however, but Chicago knew about it. They didn't bother to tell the city about that. Had we appeared at the hearing on the question of whether or not, before the magistrate, the question of whether or not it was a legal sign, I think I'm sure we would have had a different answer, but nobody appeared. That was because this occurred during the height of the COVID pandemic.
I'm going to talk about that. After what was done, once it was determined that there was a failure to attend the hearing, what action was taken?
Well, we didn't find out until it was too late to do anything. As far as it was too late to file a motion for a hearing, it was too late to file an appeal. What we did is we filed a suit in the circuit court against the city, and
Has that it's been called a due process suit?
well, some people call it a due process suit. I call it a writ of error quorum nobis, which is now a Rule 1.54B motion. And in Rule 1.54B, the Supreme Court of Florida made it very clear that it replaces the rule of writ of error quorum nobis, and it does give us the right to have an independent action. And that's what this is. The suit against the city was an independent action asking for extraordinary relief because of the fact that there was a human error and miscalendering of.
And were those
the
findings in the order vacating the prior order? Were any of those findings in that order?
No. What happened on the vacation was it was a very lengthy lawsuit, and we had three different judges. The first judge dismissed the complaint and suggested that what I was really trying to do was rid of error quorum nobis. And that's when I researched it and found out what I was really trying. And the amended complaint was very clear in that regard. The second judge dismissed the case. I filed a motion for rehearing, and the judge reversed himself and sent both counsel a list of what he wanted to us to research and present to him. We researched it. We both came to court to argue in front of him. And when we got there was a third judge in the case who knew nothing about what the second judge had done. She dismissed it. That was on appeal. But before anything could happen in the appeal, before I don't think that nothing had been filed in the appeal other than the notice. The city attorney that was handling the case went into private practice. Another city attorney took over the case. That city attorney, being aware of the deposition that had been taken in that case from the person that was actually he retired and moved away, but we found him and he came back to Tampa to give us a deposition. And he testified that he was the head of the department at the time that issued the permits, that he remembered talking to the guy because it was so unusual, that he talked to him about the problem with not being able to put up a sign for his gas station. He then talked to the city attorney and in other words, he completely corroborated everything that the owner of the gas station had said. And he said he told the owner of the gas station what to do to get this 99-year lease recorded and bring it to him. He said that the owner of the gas station did that and brought them the 99-year lease recorded. And then he approved the sign. Knowing this, and also there was an affidavit from the same person that said during several years, including the year in question, the city was so busy with files in that department that everything was kept in a room called the vault, and a lot of things just weren't filed, and things were filed in the wrong file, and that would explain why there was the actual certificate or what have you showing that the permit had been issued wasn't in the file when it got scanned. So knowing this, she also knew, I didn't, so I hadn't researched it, but she knew that if the permit had been issued, then the city would have had an inspector to inspect the sign during the construction. So she checked other files that I didn't know anything about, and she found that the city had in fact inspected it. And she knew that because of the city was inspecting it, it had to have been approved or they wouldn't have inspected it. It had to be permitted. So she called me.
You're at your 2-minute warning.
Thank you, Your Honor. She called me and said, can we stipulate that this has always been a legal sign because we have proof now that it is. And would your client stipulate that you won't sue the city? And I said, we'll be happy to that stipulation. That stipulation is in the file. It was attached to my motion. And that explains why the order was vacated. Does that answer your question, Your Honor? Thank you. So very simply, I found a case and filed it as supplemental authority. I wish I'd found it much earlier. That case was Rojas versus Best Taxi Service Corp. And it sets out the rule where there's a motion to vacate and there's a dismissal of that motion. It says where a motion under Rule 1.540B sets forth a colorable entitlement to relief, the trial court should conduct an evidentiary hearing to determine whether such relief should be granted. It goes on, a motion for relief from judgment should not be summarily denied without an evidentiary hearing. And it goes on, where such a claim is raised and contested, the trial court abuses its discretion in failing to conduct an evidentiary hearing on the motion. In this case, that is exactly what happened, and that's why we're here today. The trial court said there was no merit to the claim, although clearly I think we have proved a meritorious claim. We had a situation where we had an injury. We have a property that's worth considerably less if we can't use our sign. I must say this before my time is up. The Chicago has repeatedly said that the sign that BBK has complained about the gas station sign being on its property, and that now that the city ordered its removal, we should be happy and rejoice that it's being removed. That is 100% wrong. We have never said we complained about the gas station sign being on our property. We have always said we are complaining that we can't use the sign that we paid for. We bought that sign intending to use it with the outbuilding, or we tore that down and did something else, whatever we did. We wanted to use the sign. It was grandfathered in. We can't use the sign because of the lease. The lease is the encumbrance that causes the problem.
Sir, you're into your rebuttal time.
Thank you, Your Honor.
You'll have 5 minutes for rebuttal.
Thank you.
You have a letter?
It is, Your Honor.
Good morning.
Good morning. May it please the court. My name is Michelle Cavallaro, and I represent Chicago Title in this matter. The first point I wanted to make is that if the appellant is right in this appeal, then Judges Atkinson, Case, and Morris were all wrong in the prior appeal. Now, Judge Atkinson wrote a very thorough and considered opinion in the first BBK Santoshi appeal. But I wanted to direct this court's attention specifically to page 685 of that decision, where Judge Atkinson specifically said the court should not, and he was speaking of the appellate court, not the trial court, the court should not determine whether the magistrate's decision was correct or not when the magistrate entered that order that we're all speaking of today. In other words, the facts at the time of the summary judgment, and this is in that decision at that page as well, which is, I think, the critical part of that entire decision. The facts at the time of the summary judgment were such that BBK Santoshi could not possibly prove a breach of the title insurance policy in this case because there were no damages. And the title policy specifically provided that there was only coverage for an encumbrance against the property if it resulted in damages. And the key is the timing, Your Honor, because as Judge Atkinson pointed out, what happened with the magistrate's order after the fact? And Judge Atkinson and Judge Case and Judge Morris all knew that there was this due process lawsuit that was pending at the time. They all knew that BBK Santoshi's, in fact, main argument at the last oral argument we were here for was that this was all premature because that magistrate's order could be rescinded, it could be appealed, it could be resolved, and that everything was just premature. The trial court jumped the gun, the appellate court jumped the gun. And Judge Atkinson specifically said, that's not the appropriate time frame. The appropriate time frame is when did the breach allegedly occur and when was summary judgment entered? And the breach occurred when that sign was an illegal sign. There was no question about it. There was an order entered by the city that said, not only is this sign illegal, but you are told to remove it, which I think Judge Black, you just alluded to before in one of your questions. They had to remove it. Now, how can there be damages for an encumbrance for the lease when the lease is void because the sole purpose, and this is in the prior opinion as well as a finding of fact, the sole purpose of that lease was to create an offsite sign for the neighboring gas station. Now, if the code at the time, and it still does, by the way, provides that an offsite sign is illegal under Tampa code, and then there's an order saying, not only is it illegal, but you must remove it because now we know you have the illegal sign and we're going to fine you. And those fines will stay in place until you remove it. Then in that case, where are the damages? How is this 99-year lease causing damage to Chicago titles insured under the policy, which is BBK Santoshi, when there's no lease to enforce because that lease's only purpose was to provide a sign that in fact could not exist. Now, whether that sign can exist now doesn't matter because we can't go back in time. And this is, I think, the problem with the appellant's argument in this case is that those facts will never change for them, right? The fact that at the time there was no breach because there were no damages, that will never change. At the time, that was illegal. The second point I want to make is that
Isn't that essentially what Judge Sandra Taylor outlined in her order? What she just articulated, that the use of the property is specifically limited and under the applicable ordinance, no variance from the prohibition of off-site signage is permitted. There's no way to bring the lease into compliance with the law. As the sole exclusive purpose of the land lease is clearly in violation of the zoning regulation of the city of Tampa, and it's not a defect or encumbrance on the title.
absolutely, Judge Black, absolutely. Yes. And the next point I wanted to jump to in case, unless there's any questions from this panel that speak specifically towards that prior opinion. I don't want to spend more time on that. My second point is that if we read Rule 1 let's say we get past that prior opinion by Judge Atkinson, and somehow the appellant could convince this panel that they did have at least a colorable 1.540B5 motion because of that settlement agreement that they reached. What they're asking is they're asking for a view of that rule that is not in keeping with the letter and spirit of Rule 1.540B5, because 1.540B in its totality is meant to be hold very specific exceptions to when you can disturb the rule of finality of final judgments, which is paramount. So they carved out a rule which is very specific. And what the appellant now wants to do is say, let's not talk about when there is an order that vacates a prior judgment or prior order in this case, which would be in the sense, if we read the rule in keeping with the rest of the rule, vacate means a court of competent jurisdiction finds that prior order or final judgment should no longer stand legally. But that didn't happen here. What the appellant wants to do is now say, well, anytime we enter into a settlement agreement, if that settlement agreement, as part of the agreement, we say, oh, we're going to rescind that prior order, that portion of that order, or that portion of that final judgment, all of a sudden, does that mean that 10 years down the road, which is where we are today, 10 years down the road, one of the parties can come forward and say under a 1.540B5 motion and all of a sudden argue, well, that's vacated because of our settlement agreement. That is just not the letter or spirit of that rule. And further, even if that were somehow the letter and spirit of that rule, that it would somehow encompass settlement agreements. In this case, this was not a settlement agreement where a court of competent jurisdiction or even the magistrate who issued the order rescinded that order because it was wrong. There's been no finding, and it's not anywhere in the record, that the city of Tampa code is incorrect or has been somehow amended, rescinded, changed.
Just to clarify for me, I don't remember seeing anything, there's nothing in the settlement agreement where the city concedes all these facts that were apparently developed, correct?
That's absolutely correct, Judge Smith. Absolutely correct.
And the order that was vacated, in that order, there were fines, right, and liens that were absolved by vacating the order, right? So there was some benefit to BBK.
Yes, absolutely. And there was even in the settlement agreement, which is part of the record, in the settlement agreement, there's even a provision that, I'm going to paraphrase it, but there's even a provision that says, in the event the magistrate decides not to rescind the order, then in that case, we're just going to take away all the fines anyway.
Could the fines have been damages? I'm just, by hearing it now, and I'm putting the two together, but you're saying that you can't establish any damages today, because they weren't established back then, you have to look at that period of time. So could the liens and the penalties have been damages?
Well, I would say they can't, in terms of damages against Chicago Title. Now, whether they would be damages against another party, I don't know, but against Chicago Title, they wouldn't be damages caused by the 99-year lease. They would be damages caused by the improper sign. The third point I wanted to briefly make is that as far as the lack of evidentiary hearing, which is, I think, the appellant's final point on appeal, that only comes into play under the River Ridge, River Bridge case and the Cottrell cases. That only comes into play if there's a colorable claim for relief under Rule 1.540B5 to begin with. And in this case, there was no claim to begin with because their very claim was that all of this was premature. And in fact, the law of the case, based on Judge Atkinson's well-reasoned opinion, was that, no, it was not premature because you're looking at the wrong date. You're not looking at today, what we're doing in this appeal. We're looking at when the breach allegedly occurred and when damages occurred. And that's never going to change. So it wasn't colorable to begin with. And the final point on that I want to make is that I don't even know what the appellant could possibly have done further at an evidentiary hearing if the court had even given them one, because we have at this point over 900 pages of appendix in the record, depositions, as my colleague mentioned, an inordinate amount of evidence. And I don't know what else they would have presented because the trial court had everything already. And in fact, I wanted to point out really briefly, this 2007 permit that my colleague was talking about so much about, that seemed to be a linchpin in terms of rescinding the magistrate's order, was that they somehow discovered that this sign had been permitted in 2007. That's actually mentioned in Judge Atkinson's opinion. And so back with the first BBK Santoshi opinion, everyone was aware that the sign had been permitted in 2007. That did not sway that panel. And I asked that it not sway this panel. And finally, I don't know if anyone wanted me to touch on the standard of review, but I also pointed out in our brief that the standard of review, I think, is very clear under this court's prior decision in Leach and in the Kipps case, that it is an abuse of discretion when it's an order from a 1.540B motion. And it is not de novo as put in the initial brief. So for those reasons, Unless, are there any other questions or issues that I can answer for the panel?
Thank you very much.
Thank you. And we ask that you affirm the trial court's order. Thank you for your time.
Wait. 5 minutes for rebuttal, sir.
Your Honor, in the first case that was mentioned, what I was arguing to the appellate court at that time was that the trial court should not have ruled until there was a final determination in the other suit that I had against the city, because I was arguing that the ruling by the magistrate was not final until that suit was determined. What the court said, and I'm reading now from the Lee's brief, on July 12th of 23, while the due process lawsuit, her words, not mine, was still pending, and after the benefit of oral argument, this court entered a considered and a detailed opinion affirming the final judgment on the grounds that the lease was not a covered defect resulting in damage under the policy. And then, importantly, because the sign was illegal at the time summary judgment was entered, making the lease a nullity. This is what the judge said in that opinion. The trial judge didn't have to wait till there was a final determination, which, as you can see, took 3 years. The final judge ruled on what the facts were at that time. And what we have here is a plaintiff who or appellant who was injured, who should have been compensated by Chicago Title under the policy at all times up until there was an erroneous order that was entered. It took a while, but that erroneous order was vacated, set aside. The trial.
Were there any findings saying that order was erroneous?
In the one?
Where are the findings that say that order, the prior order, was erroneous, other than it being simply vacated without any explanation?
Okay, the Rule 1.540B does not require that there is anything more than a vacation. What we have in this case was we had one person, an inspector, who went before the magistrate and said, Your Honor, this is an offsite sign, please rule it that way. And the magistrate said, okay, because there was nobody there to say otherwise. Then we have the city attorney who has studied the matter, who's going through all the depositions, who has seen the 99-year lease, and she says, wait a minute, I need to do further research. And she finds, well, the magistrate was wrong. So she goes to the magistrate and says, the city was wrong, please set it aside. And he does. So there was no real hearing on either side. There was an order that was entered and an order that was vacated, which is all that is required by 1.540B. And the entire first opinion says it was because the sign was illegal at the time the judge was correct in entering. And that was what I was arguing, that she should have waited. And they said, no, it was illegal at the time that the trial court was right. I'm not arguing with that. What I'm saying is that under 1.540, it is exactly for that purpose. That a final judgment encompasses the law of the case. The final judgment, however, is not final until the appellate remedies are exhausted. The appellate remedies were exhausted, and we had a final decision. But that final decision in this case was based on the ruling of the magistrate, who was ruled on the city saying through one inspector, please make that an illegal sign because we think it's illegal. And he said, okay. That was set aside when the city learned that it was wrong the first time. And the city attorney went to the same magistrate and said, we were wrong, please set it aside. And he did. So now we're back in the same situation, and the plaintiff should have a remedy. How could the plaintiff go back and sue now without having the judgment set aside? Because the Chicago title is going to say, hey, res judicata. But at the time the suit was filed, the sign was legal. At the time today, the suit is legal. We have the same damages. We've had the same damages throughout. It's just that the judge correctly said, at this point in time, I can't say that it's illegal because the magistrate said it was illegal. That's the whole point of Rule 1.540, to give relief in these extraordinary circumstances. Just as at common law, relief was granted under Rule writ of quorum nobis. Thank you.
Thank you, sir. Thank you both. Okay, our last case on the docket is Reed versus Santos.